Welcome to the Recovery Lab podcast. We're glad you were able to join us. Recovery Lab hopes to destigmatize addiction and normalize recovery.
Our platform provides an avenue to share the many stories of those that have recovered from addiction, providing for the listener the most basic antidote to addiction.
Hope. All right, everybody, we're back. This is episode number 91 of the Recovery Lab podcast series. I'm Drew Hassan.
I'm Daniel Anderson.
We've got Chad King and Matthew Thompson in the house today. So our really committed listeners will remember that y'all were here. We just looked it up, December of 2022.
Mm-hmm. It was an amazing time.
I can't believe it's been that long. That's incredible. I thought it was a year ago.
Time flies.
Sure
All right,
does.
look, so a word about our sponsors.
Yeah, so today we are sponsored. Our title sponsor is A Bridge to Recovery there in Jackson, Mississippi. And as you can see, before I say anything, you've got a QR code on your screen that you could take a picture of if you'd like. Also, their website is btrms.com, and their phone number is 601-977-9353. Bridge to Recovery has... I went there when I was in early sobriety and spoke with, I met with Denise quite a few times, I think for about a year or so. And the whole environment, this was when they were over in Ridgeland, but the whole environment was just, it was peaceful, it was calm. Their leader, Costas, is just an incredible person. And she's in it for the right reasons. She's in it because she wants to help other people. I know you went there as well, didn't you, Drew?
I did. I can attest to the fantastic care I got there. I can also attest to if you complete their program and at the very end you go out on a week-long bender and show up again on Monday, they won't let you come back. So, yes.
Boundaries, perhaps.
Yes, suitable boundaries. And
Wonderful.
The appropriate consequences for doing stupid things.
We couldn't do this without you guys, so thank you so much, Costas and Bridge to Recovery. Thank you so much for supporting the Recovery Lab and everything that you do for the community.
Can I ask a question? So Bridge to Recovery, is it inpatient?
No, they have intensive outpatient.
And I can actually attest to their success because a number of our clients have actually had done their IOPs there.
Okay.
Intensive outpatient, the follow-up after treatment.
Right. The level of care they provide is intensive outpatient. So when my whole experience there, I show up and they're like, look, you really are you're a little too far gone for what we can help you with, go to inpatient and then come back. And so that's what I did. And it really is a great place. Right. It was the first time, interestingly enough, I'd ever been in a group counseling session with people that had eating disorders. And
I did a lot of work with that. I
was really surprised at how crippling eating disorders can be. That you're not, when you have a substance abuse problem, you're not taught how you can go use your drug successfully 3 times a day.
Right.
But for it's hard.
Right.
It's a really difficult spot to be in because you can't not eat.
Sure.
Right.
Well, kudos to y'all for what y'all do with this program. But, one of the reasons why I ask is because, with youth court work, we see a lot of people that need some assistance with drug or alcohol problems, and they're working towards a goal to get their children back. And so sometimes, though, it's hard for people to find like a general resource that gives you all these other resources. So when you said like a bridge to cover, maybe like this is a bit more than we can do, but they can certainly tell you
They
who
absolutely
to go to. And so sometimes it's just nice to know who's out there and where they can go.
Look, failing for a lack of information really is a sin in the modern day. Right. But people don't know.
Sure.
I had been in recovery for a long time before I ever learned of sober living and sober living houses and sober living systems. So, really, you can kind of be in the community and still not know everything that's available to you.
Right.
I can attest to that too, because we'll help people that really don't even know where to start.
Right.
And it can seem real daunting as well.
Right. And the other thing, like before I started in youth court, I had never heard of something like Born Free
Yes.
where a mom can go with the newborn.
Yeah.
Which was just an incredible service. And then, we work a lot with youth courts in the Delta and stuff that they don't have the same access to
Right.
resources available up there. They don't have a born free. They don't have, as many options that are available out there. But a lot of times, yeah, it is. It can, sometimes if you don't know the first step to take, it's easy not to take a step at all.
Right.
Right.
And so
We were recently in Harrison County at the youth court, and Judge Mike Dickinson, and he was telling us they have a visitation center. And I don't mean a room with acoustic ceiling tile and a linoleum floor and blinking fluorescent lights, but it's set up like a home. It's a trailer, but it's set up like a home, toys, appropriate space. And the parents that are participating in that youth court program and for whatever reason can't have visitation normal, they have it at the visitation center. And it's as normal as it can be. And they have a dedicated person that serves as the supervisor, but it doesn't feel oppressive.
God, that would be wonderful. I was just telling y'all. So for our listeners, Chad and Matthew are local attorneys and practitioners that seem to focus their attention in domestic matters and family law and the attendant need to go to youth court. So I was telling you, I had a trial on Tuesday for a lady who has an addiction problem, and she's going to need supervised visits, and it's part of her requirement to get back in her kids' lives. But having somewhere to go to do that so that the other parent doesn't have to be there would really be wonderful.
absolutely. And this was so great because like in Harrison County, they have this facility, but they also have employees that are there. And so you're not relying upon the other party where there may be all this animus or a family member or whatever. They can go, but they'll also be available at night and on weekends. And that really sort of is sort of the exception and not the rule for most counties in the state. But it was nice that they can provide that, like what Matthew's talking about right now with like visitation. If you're under a youth court order, for example, and the agency has custody of your child and you're getting visits, it's 1 hour every 2 weeks supervised at the agency, which equates to 24 hours in a year.
Two hours a month is what you're getting to rectify, reunify, whatever that situation is.
Right. And that's almost impossible, for any parent to sort of create or reconnect a bond in that period of time. And it's just not a friendly environment. Now, that is because of lots of reasons, but the main reason is because if you have a worker that's supervising it, I mean, we have as of Friday, we had 4,094 kids in state custody. So you can imagine trying to schedule not only around court hearings with the federal and state requirements of going out to the house twice a month, and then also just finding time to supervise a visit. If the kid's in school, then we know we can only do it from like 3:30 to, there's just lots of reasons that go into that. That's why this visitation center was such an amazing idea and program that they have down there.
And shocking that it's just as rare as it is. You would think or assume some of the more wealthy counties in Mississippi would have those, and they just don't. Not yet.
But hopefully soon. I think there's a lot of push now to sort of, number one, strengthen families. Number two, make a more uniform youth court system.
That was my next question.
Sure.
These are county and region specific.
They are. So right now we have 24 county courts in the state, and then we have 58 chancery courts that handle youth court. So I'm talking about just agency involvement with a family. And so those run off of those budgets. It's either your county budget, your county court budget, and then, of course, it's supplemented by the state, obviously, with that funding. But depending on where you are, you may not have the same access to things, or you may not be able to. There's a lot of these counties that have things like this are through grants, not necessarily through the state budget. And that's just the nature of where we are. We're in the poorest state in the country. Well, we just don't have the same resources or availability. And so a lot of these grants and stuff are being very helpful and used to bring stuff like visitation centers that have playgrounds and then just bringing in professionals that are available that can help, rather than the agency saying, oh, you need to go get, this mental health assessment. If we can get some money to bring in people there at the youth court to come in twice a week or whatever, they can do the mental health assessment. Because once again, we find ourselves with 83% of the cases that come through this state are neglect, and there's usually a poverty related issue. So it's not easy to say, oh, well, get in your car. They may not have a car, and come down here or go to this place, or you need to go next to a neighboring county because they have a facility. I mean, there's just things that have to really help people and diligently assist them in this reunification with their service agreement that makes the nature of our poverty issue, it makes it hard. Yeah.
Gosh.
And the other overarching issue is the lack of consistency between those varying youth courts, the youth court judges, the referees or designees, and how they run the courtroom and what resources are made available. There is the only consistency is inconsistency.
Right. Yeah. And they're confidential. So when you find the inconsistencies, it's usually we've already done damage, and we've had all these months where it was sort of insulated. And so we didn't know. But I do want to say there is a big push statewide, and there's a huge new sort of, the commissioner of CPS, Andrea Sanders, just done an incredible job of bringing a lot of this to light, trying to get consistency with our youth courts and with our parents, and really trying to focus the efforts to where they need to be. And that is to strengthen and reunify families faster, because as the state, we don't want to raise your kids, and we don't want to be a foster program. It's not what we want, and it's not what our goal is. So.
The confidentiality that Chad mentioned is, they want to keep children's identities private and protect them, and maybe there's this heinous abuse allegation, and the thought or impetus behind it is we got to keep that private. But what it does is it creates this veil of secrecy. Any other courtroom in Mississippi, you can go watch. I could go watch Joe Blow's divorce. I don't have to be the attorney of record. I can just bebop down there. Anybody can. Sit in the back of the courtroom. You can watch. You can hear the testimony about their private matters and their financial information. Circuit court. I can go watch a car wreck. I can go watch a murder trial. I can go watch a criminal trial of abuse allegations that involve a child if I want to. That's public.
Well, I think you can watch murder trials online. I heard there might have been one recently.
Yeah.
That was streamed live everywhere.
But if I want to go watch youth court, I either have to be a party, meaning one of the parents, or I have to be counsel of record for one of the parties, or else I'm not allowed in there. I'm not allowed in there as an officer of the court. The public is not allowed in there. A foster parent may not be allowed to be in there who actually has possession of the child at issue because of the confidentiality.
Secrets don't make friends.
Correct. Yeah. I mean, and that's how, the stigma was.
Well, what oversight is available to ensure there is at least a modicum of continuity or?
Well, from a legal perspective, the oversight will be appeals and case law. But again, because it's not a heavily practiced area, that's why we don't have robust case law. I mean,
who's going to pay for that appeal?
Correct. And so it's the same, OSPD, the Public Defender's Office, they've taken on several appeals, trying to sort of get some consistency. But it's important to remember, youth court is an inferior court in that it's statutory. So all of its power and jurisdiction derives from statutes. So it's getting your legislators. I mean, if there's an issue with some of that, it's a legislative change that has to happen. And so there was a big push this last legislative session. It didn't go through, but what they were trying to do is to get some consistency, maybe, is try to pull youth court under chancery court. So we only have 24 sort of outliers where youth court is under the county court versus Chancery Court having a referee or a designee appointed. And so it's sort of an interesting system because it's so different. We used to have one municipal youth court in Pearl, but it closed. So it was always interesting. It was like you're either under a chancellor or you're a county court judge, or you might be under this one municipality.
Pearl Municipal Court was like the Wild Wild West. You didn't know what you were getting.
No.
I mean, rules, procedure. I mean, it was the whim of the day.
And I know that's frustrating as a practitioner because you don't know what you can tell your client, and you don't know what the best approach is, and
Well, I'll tell you
it's got to be.
what's most frustrating for me, and probably the scariest thing for me, is that we're dealing with a fundamental right. I mean, we're dealing with a parental right that's fundamentally protected, that's been recognized as far more precious than any property right out there. And then we have an inferior court system dealing with that fundamental right. And in the 24 counties that I talked about, they can go on to a TPR. And so you're talking about the death penalty of families, and it's all confidential and sort of wild, wild west. And you're thinking to yourself, wait a minute, this should, if it's the death penalty, treat it like the death penalty. And let's get some consistency in here. And, so you may have a TPR in a county court where it's all sealed and confidential. But if you weren't in that county court, you would have a TPR in a chancery court, and they're not necessarily sealed. Like, you can come in the courtroom, you can call your witnesses. So it's just it's sort of again, it's broken right now. And
Do y'all know any other jurisdictions that have systems that are superior?
Like other states?
Yeah, like in y'all's studies or in your research, like, if we could only get it like Florida's got.
We're the outlier in how we do it. We're certainly in the minority of states that do it like this. Chad will tell you about the different models.
Well, so a lot of other states, they have what you call an agency model where CPS actually brings the petition because they're the ones that are out investigating it. We have a prosecutorial model. So we have a county prosecutor that's bringing these cases in youth court. And so, there's pros and cons, I think, to both. But obviously, a pro is that if the agency's investigating it, they have a little more prosecutorial authority because that's now their position, versus right now they're sort of dependent upon a prosecutor who, just is not as invested, not because, they just have a lot on their plate, I think. All prosecutors are like, they come in and there's like a stack of cases. Anybody that's been to a speeding ticket knows that when you go in that courtroom and there's a million people in there, that prosecutor, they haven't looked at your case. They don't know anything about you or your speeding ticket. And sometimes it can be the same way in a youth court, depending on how that prosecutor's office sends people in. We do have a couple of counties where they have a dedicated prosecutor, which seems to be better. But there's lots of states that have lifted confidentiality, but left an avenue open. So if it is a heinous sexual abuse or something that Matthew talked about, the court could seal that matter. But like for the majority of cases I'm talking about, like neglect because you can't keep your lights on, or you can't pay your power bill, or you don't have enough food in your house, or you need some help with housing, why on earth would that be sealed? I mean, like that, we want all the community to come together and help everybody, but you can't talk about it because it's confidential. And again, that creates that stigma of failure and, this is secret. And we don't make friends. And so, again, I think if we had, there's some studies out there that shows how different states do it. We are sort of in the minority, I think. We're just sort of, our Youth Court Act is from the 80s, and it hadn't changed much. And so I think maybe there was good intentions behind it, but it could definitely use a refresh. And there's lots of states that even have poverty issues like Mississippi, but seem to be doing a better job of permanency and getting kids back safely quicker. That's our thing. I mean, our kids, they just sit around in custody for so long. Either way, whether they go back or whether we go to a new permanency plan with developing a new family, it's just the timelines are so long right now. That's a problem.
We've done a handful of CPS adoptions of children that have been in state custody for 4 to 8 years.
Damn.
Yeah. I mean, that's just wild. I mean, it's such a it's a long road. And again, you know, we did a foster parent training yesterday with Catholic Charities, which was great. Some of the families that we had finalized adoptions for were there getting their required training for the year, and it was good to see them again. Kids are doing great. And so you really do get to see both sides of it. You get to see, do we need to remove? Is there a safety concern that we would remove? And there are cases where parents should not get these kids and back. And that's just the reality of some horrific situations. But to me, those are always the easiest, because there is some horrific sexual abuse, physical abuse. There's all kinds of physical evidence. And it's just clear cut. It's the harder ones are the ones where it's like, okay, we need you to get stable employment, stable housing. Well, most people, if they could get that anyway, they would get it. I mean, there's not a ton of people that I think like to wake up in the middle of the Delta and
they
just
certainly
be poor,
realized
right?
their problems long before CPS got involved.
Correct. And one of the things that I pointed out yesterday is, like, you got to keep in mind, so if we have a mom that can't pay her bills and maybe she works like an hourly job that is not 9 to 5, is not 40 hours because they don't want to pay her health insurance. So she may struggle to make it. And then down the road, maybe grandmother who also grew up in poverty and only has a limited income and can barely survive herself and is barely surviving. If we're like, hey, will you take your grandchild? She may desperately want to take her grandchild, but she can't get licensed as a foster home because she doesn't make enough money to support that child too, because that's a requirement. So that means she won't get a resource payment. And so she won't get help from the state because she can't meet that licensing requirement. So the only way to bring that child in her home is to say, I waive those payments. Well, putting that child in her home may be the difference of whether or not she can pay her light bill next month. So now we're back to the same problem. You know, it can be generational in that sense. You know, I always say, people will say, oh, well, poverty can be a motivator. You know, pick yourself up by your bootstraps. It's hard if you don't have boots. And number two, while it could be motivational, it can also be a conditioner, to where you feel like it doesn't get any better than this. I mean, I've grown up like this, and you know, it's just that is an issue that is just part of the environment that we live in with being a poor state. So,
and
I need y'all to start telling some happy stories.
I know I was about to say, are we bringing the mood down?
So I was going to interject. The other thing that is good about CPS in the youth court system is they do work with these parents, and they do provide the resources that they can with job training and with parent training and resources for substance abuse issues. And so these things are happening and they are making a difference. We just don't hear about the success story so much.
Right. But there is now a big push. It's interesting. We've got some courts like Hinds County Judge Hicks. She does a great job of having like reunification celebrations. And so it really is celebrating these parents that, you know, again, it's not about becoming ideal. When we're talking about getting a child back in a home, it's always as quickly as possible if they're safe. And so we're not trying to meet this benchmark of, oh, you should be making more money and have a better place to live. It's whether or not is that child safe, because that's really the only reason why the government should be coming into your life and saying whether or not we should take your kids from you. It's a safety assessment. And so, but she does a good job of celebrating that, because it's work and it's hard, but sometimes all you need is a helping hand. And that's what the agency's there to do, is to help people.
Well, it seems like that all this does is just underscore the need really to make this a state thing and not a county by county thing.
Correct. Yeah, certainly there should be some consistency within that youth court system. You know, I know everybody, you know, always says, oh, well, you know, even in Chancery Court, you know, like different districts do it differently. However, like Matthew has pointed out several times, but the basic foundations, you know, the basic foundation of a, you know, Ferguson factor for an equitable distribution or an Albright factor for are all there. You know, again, that's the thing about youth court, is that there's all these players that are running on different timelines for things, and it is very inconsistent, very. And because it's sort of secretive, not a lot of people know. So That's why we're talking about it.
Spread the word.
We can only fix it.
It needs to be talked about, and if not challenged, at least questioned. Because who does the confidentiality really protect? Ask
Right.
that question.
Yeah. So, but it's been a really interesting journey for us. I joked on Wednesday that I know, like, when I first came out and started practicing law almost 10 years ago, I told Matthew that I was going to work in youth court, and he's like, "Oh, that's the bottom of the barrel." And so here we are all these years later, and he's, with me at the CPS conference. Like, again, once you get into it, you think, oh my God, we do have the chance to help fix some of this and help people. And we do lots of adoptions. And so I get to see both sides of it. And, but it's good to get in and go, okay, how can we fix this, and how can we really make a difference? And this is how, doing things like today and talking about
Well,
it.
it's got to be so rewarding to see, instead of just seeing only how the sausage is made. You get the end result of an adoption, and maybe figure out ways to help expedite the process and get to that point of stability.
Correct. And, yesterday it was so fantastic meeting some of those foster parents, and what they seem to be so grateful for is that someone explained to them, like, how a youth court case works, because they don't always get that information. Foster parents, they don't have even custody rights. Sometimes they're not even allowed in a courtroom. So then again, it once again creates this divide, even though they sign on to be an agent of the state to have these kids in their home and to work with birth parents. A lot of times they don't even know birth parents' name or contact information. And they were like, well, how can we, can we call them? Can somebody give us that information? And you're thinking to yourself,
Well, it
oh my
all
God.
will make your head spin. Last month at Madison County Bar had Stacey O'Neill,
Correct.
the county court judge from Madison County, or one of them. And she and a couple other people were talking about youth court. And, they gave us not a spreadsheet, a flow chart of sorts, with all these deadlines. And
Right.
your head, you think,
That's right.
I'm a lawyer, and it was confusing to me.
It is. So, and the reason why we have those deadlines is because that's federal policy and our state policy, which we've codified too. But all of those deadlines run because of funding. All that federal money that's tied to coming into the state to help keep our agency afloat and keep
Those are
child
some
welfare.
of the conditions.
Correct. Those timelines and permanency timelines are linked to that federal funding. So, and again, because when this was put in place, honestly, the government's like, if we have to come into your life, we want to be in and out. So, if we have to take your child from you, like, we want to have a hearing within 48 hours, and we want to have a trial within 30 days, and then we want to be working towards getting them back, no more than 6 months. And so, but because, the sheer volume of cases, they can be continued for good faith. And, we have lots of continuances in court. We really do. And again, that's another thing that foster parents are like, man, all this keeps getting continued. We've now had this child in our home for 3 years, and they hadn't even had a trial yet. And they just think that's preposterous, which I do too in this circumstance because it's youth court. But you think, Drew, when we all three worked together, what was the longest divorce case you remember? How long it took? I tried to think back about that the other day. Sometimes you have
a couple of
years before we had a divorce, and then probably it was appealed. So what would you do? Add another 2 years?
Yeah, 18 months.
There was, I don't want to say her name.
Correct.
There was a lady from Meridian who was married to a
Right.
physician. There were two of them.
That was Joe Blow.
And they went on forever.
Correct. Oh yeah, that's what I was thinking of too. And so yeah, it did. It went on forever and ever. And then, you have the appeals. And then if the appeal is reversed back to that trial court, then you're going back to court again. And so I always get tickled when somebody will come in and, we'll have an appointment. And they're just, like describing the worst spouse in the world and how they want to take them to the cleaners. And they were like, do you think this will be done in 3 months? And I was like, no. again,
But I read on the internet it
Right.
only takes 60 days to get a divorce.
Or my friend's case.
right.
They got divorced over the weekend.
Yeah.
Sure. Yeah. No, it's always interesting.
Look, one of my favorite things is, and if you're listening to this, please know there is no mechanism whereby an attorney can arrange for you to go talk to the judge.
Right.
That does not happen. You can't go sit. Look, I just got to tell the judge no.
Is it a good idea to write them letters?
So the way you tell them is on the witness stand, and
Right.
there is no meeting the judge.
That's right. Yeah. Yeah. And in fact, judges are specifically prohibited from that in their judicial canons. It might be judicial canon number 3, where if they had even talked to you, they would then no longer be your judge. So everything you said to them would no longer matter.
Wait,
Anyway,
are you saying ex parte communication is not allowed?
it is not allowed under the judicial, let me put that, under the judicial canons. And so, again, no, I agree 100%. And Matthew's right, too. Don't write them a letter. Or the other thing that people seem to think is if they call, 3 on your side or whatever news thing or whatever, and, if they could just get their story told, that's going to change the judge's mind. And I'm like, that's a basis for recusal. So
Yes.
The judge would never go. And, again, it's very rare that I think it's sort of like if you're in a sticky situation with a criminal investigation, they're not ever interviewing you because they think you're innocent.
Right.
Ever. Just like you're not going to
Wait.
win your case on the side of the road.
Wait a minute. Law enforcement's not just trying to help you out.
So some people say, oh, well, they just want me to come in and talk to them so I can clear all this up. No, they don't. And that's not to bash law enforcement. They're just doing their job, but that's not what they're there. And I've never met someone that was under a criminal investigation or was going to be interrogated or whatever that the police officer went, you know what, now that you've told me this, I'm so sorry. You're right. You are so right. We were 100% wrong.
My good friend John, his dad he recently passed away. Mr. Houston was a fantastic attorney from Bay Springs, and he would say, what possible good do they think was going to come of going
Right.
of going to talk to the police?
Correct. And
What possible good did he think that was going to do?
You have the right to remain silent, but we do not have the ability at all.
That's
Yeah.
correct. Yeah. And that's because I think we naturally just be like, oh, if we could just tell our side of the story, someone would understand. But the person on the other side may not be wanting to understand your side of the story. They may have already made their mind up. So
Right.
what they're looking at are things that help them reach the conclusion they've already made. And so, be careful with that. I always tell people, don't ever go talk to the police without a lawyer, and stop trying to win your case on the side of the road. It's just never,
it ain't gonna
never
happen.
going to happen ever. So that, that's probably why I don't do criminal work. It's hard, and I don't know that I could do it, but yeah. So going back to the timelines, it's just I think that when we have people that are going through a divorce, the other thing is always explaining to people, yeah, we have divorce laws, but every divorce is different in the timeline. People think even ID, they think, oh well, we can get an ID divorce within 60 days. Well, 60 days from after when your joint complaint is filed. So if nobody signed a joint complaint and filed it, your 60 days hasn't started ticking. If you hadn't done your financial disclosure, we can't do a property settlement and child custody support agreement yet. So everything is contingent upon something else. But there's a lot of, I will say I've seen sort of an influx, I feel like recently, of sort of do-it-yourself divorces. Have you seen these? That
Every
come
now
back
and then.
later. So these will be ones that were entered, 4 years ago, but they were clearly maybe like a legal
E-forms.
website or something that they went to that may or may not have been Mississippi specific. But we've had a couple of cases where we've had to go back and ask to void the judgment or open it back up because they'll have things like child support ends at 18 in there. And it's like, again, I think people don't understand that sometimes there's some judges that when an agreement comes through to them to sign a final judgment, especially if it might be a pro se litigant, they're not necessarily reading everything. A lot of times the judges depend on us lawyers to sort of give them a sort of a recap of what's in there. And so, again, if there is stuff in there that's contrary to state law, like you can't build in that once a child is 14 or 16, they can choose where they live and custody modifies based on what the child wants. I mean, again, we can't take away that judicial function of modifying custody. But we've seen a lot of cases lately where someone's brought us an agreement from years ago that they just all did themselves and signed. And it's like, no, this is going to be, now it's going to cost you money to go back and try to fix some of this. And
now that you mentioned that, Ernie had a case where the two parties to a divorce who they had always worked together in the family business, and their divorce. I mean, I don't know where they got the agreement, but if you can't be in a marriage with somebody, you really don't need to be business partners with them either. And there was this really intricate system of property division and ownership, and then when the property gets sold, whenever, then you split the equity. And one guy, he sold a piece of property and split it, and then he got smarter the next time, and he didn't sell the property. He just quitclaimed it to his new wife, and he was like, "I didn't sell it. I didn't get any money for it." And so, yeah, don't do the e-forms divorce.
Don't. And again, I love it. I mean, I don't love it, but I love when people think like a quitclaim deed just satisfies everything. It's sort of like if you have a car that has a lien on it, well, you don't have the title to sign over. There's a lien holder. Same thing with the mortgage in the house. There's a deed of trust.
Right.
And the bank's over there going, no, I made this mortgage agreement with the two of you. I mean, I don't care if y'all are splitting up or not. Y'all both agreed to pay me my monthly mortgage. Same with the car. And I get it. Right now, it has been a horrible time to try to refinance a home with interest rates. And it's very horrible to refinance a car anyway, even when there's a good interest rate. And so I know that that's been sort of a hindrance to a lot. But I don't have the same opinion as the validity of an indemnification language in an agreement. Even though they say, I will keep this car, even though we're both on it, until it's paid off, and I will indemnify, defend, and hold you harmless if I don't make those payments on time. Well, Capital One or whoever has your car loan, they don't necessarily care that other person has been indemnified now by a chancery court judgment out of, wherever Mississippi.
If they weren't a party to.
Correct. And so again, and that could potentially mess up, if the ex-spouse gets mad and goes, I'm not going to pay it. Like ruin your credit.
Yeah.
Because of that. It's just hard to sort of untangle some of those things sometimes, especially when interest rates are awful. Matt, why are you making a face like that when I said that?
I was just thinking about the contempt petition I could go file about the indemnification issue.
Yeah. And so how quickly you think you get that heard?
Well, the rule says I get a Rule 81 summons issued, and it can be tried within 7 days.
Yeah, well, I didn't ask what the rule said. I asked how quickly.
In real life, yeah.
That's the thing. The damage could be done. Like they could not make a payment for 90 days, and you may not have even had a court hearing within 90 days on the contempt. And then what do you get?
A sheet of paper that says they have to pay you back.
One of the biggest surprises I had when I started practicing was somebody would come in and tell me some story, and I'd be like, you know what? You were absolutely done wrong. And if you sued them, you'd probably win. But it didn't work. No attorney's going to do it because they don't have any money, and whatever is not X, Y, and Z is not insured. So
that's right. Or it would cost you more.
Yeah.
To go after this. I mean, some people, they do want to go after it just because of principle. But we're very upfront with people too, to say you're going to spend way more than you would ever recover from this. And that does, that is unfortunate that there are situations where it's like, it's not worth it, even though deep down, this should not have happened to you and this should not have been done this way.
Yeah.
That's the hard, that is a hard part, I think. And I do think that sometimes it's also hard when you know that a judge made the wrong decision, but there's enough that they had, even though it's wrong, there may not technically be anything to appeal because they did have the discretion to make this decision. And that's hard too.
Well, so that people can follow along.
Yeah.
In for appellate work, and I'm not an appellate expert, but chancellors, the judges that Chad's talking about, have exceptionally broad authority to rule however they want to rule. And you will occasionally even see an opinion from the Court of Appeals that says something like, well, we may not have come out with the decision that this particular judge did, but that judge ruled the way he did is not an abuse of their discretion.
Correct.
And even though even we can disagree, and that still isn't a sufficient basis to overturn or reverse or remand for additional findings.
That's right. And so appellate courts, Court of Appeals, and Supreme Court, they don't go into a case thinking, how would we have ruled? They go into it looking at what that judge did and then saying, was there a clear error of law, or was there an abuse of their discretion? And so in almost every aspect of a divorce, equitable distribution, equitable distribution, we have Ferguson factors. For custody, we have Albright factors. Alimony, we have Armstrong factors. And there are all these factors that a court should look at and weigh. But the thing is they get to weigh them. So they get to put whatever weight they want on any of those factors. And then you're just looking at, did they abuse their discretion when they did that and when they did that. The other thing that judges get is they're the only ones that get to view the demeanor of the witnesses that testify in front of them, which is also a weight that they can put because they are determining, they're the trier of fact, they determine the veracity of the witnesses in front of them. So there is, they get a lot of leeway in that sense. And that's what's hard is when you feel like, man, I just couldn't get there. I couldn't get this judge to see my position, but technically, there's probably nothing. You're making a face.
You only have a brief moment in time to put your snapshot of reality in front of the judge. And,
that's right.
And sometimes they have their own own automatic and internal biases, and maybe you can't overcome that in the brief amount of time you have in front of them.
And, you're giving them that snapshot, and then sometimes it can work against you. Like, say if someone, one of the spouses always was screaming and yelling. Well, if they were always screaming and yelling, that was sort of the normal for that. It may not necessarily...
You married a screamer and a yeller?
Correct. Mere unkindness and rudeness may not, equate to whether or not you get a divorce. And so anyway, I agree. I think it's an interesting, I have seen lately there's been some that have been reversed and remanded. And that means the Supreme Court doesn't agree with it and they send it back to the same judge in the same court to hear again. It's very rare that they ever render a decision, that the Court of Appeals goes, now I'm going to make the decision for them based on this. But a lot of them have been reversed and remanded, or several have been reversed and remanded lately. Because a judge failed to even address any of those factors we've talked about. Like, they don't even talk about the factors, which I found mind-blowing because, again, if I was a judge on the bench, I would have just like a little script thing with every single factor that I have to address.
like the way it is when you enter a guilty plea to a crime to check all the boxes.
That's right. Yeah.
I did a case out of town and relatively short marriage, no kids. Our guy was a high earner. Wife was not a high earner, and judge did permanent alimony. Not a tremendous amount, but permanence for the rest of their lives or until the wife remarries. And he wanted to appeal it. And so did some legal research, pulled every appeal that had involved that court on alimony. Ended up finding 10 reported cases. And all but one had been affirmed. The one that was not affirmed was the very first one that was done, where they did not talk about all of the factors. And it affirm, the one that was reversed and remanded, it didn't change the outcome. You didn't win that appeal. It just said, go back, address the factors. Well, they went back and addressed the factors. It had the exact same
outcome.
And from that point forward, every alimony case that judge did said, here are the factors. Factor 1 favors an award of permanent alimony. Factor 2 favors an award of permanent alimony. Whether it did or it didn't, judge said it. So at that point, it did. And I told the client, it's not worth doing an appeal. You're going to lose. You're just going to be paying for my kids to go to private school.
Well, there you go. Well, and it's interesting to me because there's also appeals are not quick. You know, there's, you know, and there's an expense to it. You got to pay for the record to be prepared by the chancery clerk. That's where they get all the papers together. You got to pay for the court reporter to get you a transcript of the trial. And then,
and if you're a party, you're going to live under the terms of the order that you're appealing.
Correct.
So, you know, say you get stung with some, you know, in your mind, an overly large child support amount for whatever reason.
Right.
Well, go appeal it. And I guess you have to keep paying that.
That's correct.
Yeah. For 18 months, you're going to pay it. And then if you win, you may or may not win. You may get a do-over. So you get to pay for another trial.
Right.
And it may or may not change the outcome.
Yeah. And so there's very few things that can ever be stayed on a final judgment. And if there is like a big property distribution amount, child support can't be stayed, obviously. But if there was like a big, you know, you got to pay this person $250,000, you know, the only way to stay that would be to post a supersedious bond, which would be 125%
of the
$250,000.
Look, I have often said, you know, for people that might think this is interesting, circuit court judges can certainly put you in prison for the rest of your life. And they can even, I guess, in extreme cases, order, you know, the death penalty or impose that on you. But if you want to get into who has the unique ability to invade your life and change it today without notice to you, it's the chancellor.
Right.
It's incredible the amount of get into your personal life. I don't even know who you are. And all of a sudden I get served this order to do X, Y, and Z, you know.
Right.
It's scary.
It really is scary.
And it happens.
Right.
I mean, it's almost unbelievable how much power, you know, if I'm willing to lie, I can swear out an affidavit that you've done something, and I'm afraid of you and whatever else. And I can, you know, persist in my folly and take this to the chancery court. Well, they're probably going to give you your restraining order. And I mean, imagine you haven't done anything and all of a sudden some sheriff shows up and says, you can't go home.
That's right.
For the next however many days. Like if you go there, I'm going to arrest you.
Yeah.
That's scary.
Right. And sometimes don't have any contact.
Yeah.
Either. Or with the person
don't
or the
call,
kid.
no smoke
sometimes.
signals. Don't get your friend to text. Nobody.
Right. No third party can contact. And then you're like, oh my gosh, I'm in this bubble of, you know, what do I do? Yeah, no, it is. It's scary. You know, it was always scary to me too that, you know, again, anyone can call the hotline or get online to CPS and make any allegation they want to make. Like I could call right now and say whatever I wanted about somebody that has kids. And there's literally, but you know, even though we have a law change where it can be a crime, but it still starts that train leaving the station with a worker going out. I mean, a worker could just show up to your house and say, we've had an allegation that you whatever. That's terrifying to me. And they can show up with law enforcement, depending on the allegation. And that can start the ball rolling way fast. And you're thinking, wait, what? Just because somebody picked up the phone and called, at least in that case, you have an affidavit and you're at least seeing a judge. I mean, and then, based on that allegation, a judge can give an order over the phone without ever even talking to you, meeting you, anything.
Nothing.
It's terrifying. And it happens.
Yes.
No, it does. But I'll tell you, we do have some quick, at least with that, we can get into youth court within 48 hours. So, I mean, we're supposed to, a defendant can get back into chancery court if they request it within, but a lot of times that hearing may be set for 2 weeks out. Like if you swear out an affidavit and got an emergency in chancery court, they usually do set a follow-up, but depending on the chancery and how busy it is, I mean, you're right. That could be for a while before you're even going back in there.
There are certain aspects of chancery court practice that really, one thing that, but it still even blows my mind. I was completely surprised when I learned or realized that I could get a summons that said I've got to be at the courthouse November 5th at 8:30 a.m. And it blew my mind that I would get there and not a damn thing would happen in my matter until 2:30 that afternoon. It still blows my mind that happens.
Oh yeah, I was. Somebody had brought up going to a docket call. Matthew and I were actually in North Mississippi.
I miss DeSoto County. You can say
Yeah,
that.
for a case, and I mean, it was literally standing room only.
There were probably 50 attorneys and hundreds of litigants. I mean, it was a mass docket call, and
For what purpose?
That's what they do. That's what their district does.
It was Monday morning, and Judge started.
Were these all like stale cases that's been no action on for some period?
Oh no, these were. I mean, there were 50 cases in various, states, and people were getting trial dates. They were having hearings. They were entering agreed orders. They were asking for continuances. They were asking for additional discovery. I mean, it was everything that runs the gamut in Chancery, and it's just how they do it. And I mean, it was like a somewhat of a family reunion because, oh, hey, how you doing? Haven't seen you in a while.
Right. They had a spillover room. There was a spillover room, Drew, for lawyers. I mean, when I tell you they were like lining the walls of the courtroom and then a spillover room because it was outrageous. And outrageous because there was a lot of litigants there that, I mean, I think Matthew went up to somebody that practices up there and was just like, tell me when you think we'll go or be able to just talk to the judge before we even have a hearing because he's just going down this huge docket. And they were like, what, 3 o'clock?
He said, well, you'll get out of here by 5 or 6. We were 47th on the docket.
47th. That's what I'm talking about. It blew my mind that it was so inefficient.
Oh, right. Yeah. Because it's hard on lots of people that have to be there or, plus people are nervous when you have court. I mean, even lawyers are nervous. I mean, there's sometimes I'm going into court and I'm thinking, well, I better call Drew and Matt and see if they have bail money. You just know that, you're in a, unfriendly court or you're in a court where, maybe a judge shouldn't be a judge. And you just know that you're going to have to bring up some stuff that they won't like. And so you never know what you're going to get. And so, yeah, there's lots of times that I'm like, I'd rather be anywhere but here. But you got to do what you're going to do.
You got to do what you got to do.
It's interesting. I mean, I think the society thinks there's this good old boy system between the lawyers and the judges, and I mean that's not our experience at all. I mean, there really is a divide. We've had lawyers that became judges felt like you lost a friend because you can't go to dinner anymore, and they lose their first name, and some of these courtrooms, I mean, it feels like a hostile work environment.
Yeah. Or sometimes, I think some, if you were friends, which, we all, every judge that usually makes it to the bench, we've all practiced with, or we know usually if we're from around the same area or if they feel like they have to be a little bit harder on you because they were friends with, or colleagues or whatever. But sometimes that happens. It goes the other way. Or they feel like they can be harder on you because they know you and they know Yeah, but I remember we've been in lots of counties where, I mean, walk in the door and it was like, oh, here comes one of those Jackson lawyers.
Yeah.
You're thinking, isn't that relative? Isn't that like being like the tallest munchkin in Munchkin Land? You know, like who cares?
I'm from Brandon.
Well, metro area.
I'm from Pelahatchie, actually.
If you're outside of the metro, you're a Jackson lawyer.
Jackson lawyer.
It doesn't matter. There's no distinction between Rankin and Madison and Hinds counties if you're, out of this area. And he's not speaking anecdotally. Like a judge literally said this to us within the last 60 days. Y'all did pretty good, even being Jackson lawyers.
Isn't that so silly? Like when you really think about it,
it is silly.
Like, come on, who cares? But I guess it's just one of those things, depending on where you're from. Like Yazoo City.
Yeah. Look, I was with Ernie one time, and he was trying to get his fees approved from this estate in the Delta, and that judge was like, man,
yeah,
he let Ernie have it.
There is a significant difference in the approved hourly rate depending on where you are geographically in the state.
There's a tremendous difference between Madison and Rankin on that
Correct.
matter.
Yeah.
You know, I've been involved with Ernie trying to get some attorney's fees in contempt matters, and the judge is like, I mean, maybe you can get that in Madison County, but
all of them sound like a John Grisham judge, don't
yeah.
they? Like, maybe
oh,
you
look,
can
there's one, and he was one of my favorites that in my travels with Ernie. I mean, like legitimately sounds like Foghorn Leghorn, but he was pretty cool.
Yeah,
pretty cool.
Well, and that's the thing. It's like, I get that, but because there are some judges, like even on a contempt, where they have it in their mind, this is the most I ever give anybody. Yeah. Like they just have a set fee that, like, if you're gonna ask for attorney's fees back, this is the most I ever give. It doesn't matter how long it took you, how much discovery it took you. This is it. And then you have other judges that are like, give me your bill and we'll look at it and determine what's reasonable.
Yet a fantastic exhibit, an example rather, of the broad discretion that chancellors have.
That's right. So even for that, they get to determine what they think is reasonable. And Matt's right. There are some counties where it's just, it would be unheard of for what, some bills that they see. Mm-hmm. And I've seen some of those ridiculous bills. Being on the other side, I've been like, there's no way that anybody paid this much or should ever pay this much for that.
Well, y'all, we're about running out of time. Is there anything other topic y'all wanted to touch on before we have to scamper out?
Yeah, well, this is what I want to say. So, if for y'all to say this, do y'all have like on y'all's website or Facebook like a list of resources? Like I know your sponsor today, Bridge to Recovery.
We do. It's all going to be
it's
all going to be at recoverylabllc.com.
Wonderful. And I just want to say thank you. Thanks for having us again and letting us talk about what we do.
Well, just think about how often you'll be able to talk about what you do when you start your own podcast.
Oh. Yeah, that's
okay.
And I apologize for being so. But I mean, I'm kind of up against the wall. I got 3 attorneys here in the studio, and I'm sitting here with a GED. So I was soaking up as much as I could, and it was a great conversation. I learned a tremendous amount today. So thank you guys both for coming in, and thank you again to Bridge to Recovery for sponsoring the show. And we will see you. Who do we have next week? We have
Michelle Richardson.
Michelle Richardson. Awesome. Well, guys and gals and everything in between, thank you so much for coming, and we will see you next week on the Recovery Lab.